You're live.
Thank you, Chris. Welcome, everyone. We have a lot to do this morning, so we're going to try to move quickly. Thank you all for coming. I know you've come from all parts of the state and we appreciate it. And let's begin by calling the roll, please.
The Honorable Sharon Keller,
Here.
Mr. Jim Becky,
Here.
Mr. Alex Brennan,
Here.
Mr. Jay Cohen, Honorable Valerie Kobe, the Honorable Brandon Creighton, Honorable Richard Evans,
Here.
the Honorable Nathan Hecht, Honorable Missy Maderi, Honorable Joe Moody, Honorable Sherry Raddick, the Honorable Reggie Smith, we see that he is here. The Honorable Vivian Torres, the Honorable James Woolley.
Here.
Judge, we have quorum.
Is there a motion to approve the minutes for the June 24th and 28th, 2024 meetings? That's okay. Can I hear a second? All in favor? Any opposed? The motion is adopted. My report is going to be brief. A number of years ago, TIDC instituted an award to be given to an individual or a group who's made an outstanding contribution to indigent defense in Texas. The award honors and is named after Robert Dawson, who was professor at UT and who early on started providing interns for TIDC and helping us get moving. This is not an annual award. We've given it only 9 times in the past 22 years, whatever. And it's gone to people like Jim Becky, Tony Cavello, David Slate. And so it's really a very special award. This year, TIDC is presenting the Robert O. Dawson Indigent Defense Distinguished Service Award to Judge Roy B. Ferguson, the 394th District Court. Judge Ferguson was nominated for the Dawson Award by James McDermott, Chief of the Far West Texas Regional Public Defender. So every now and then, probably in any profession, but certainly among judges, someone immediately stands out as a paragon of the profession. Judge Ferguson is one of those people. He's thoughtful, inventive, and tireless. For those who don't know, Judge Ferguson really is the father of the Far West Texas Regional Public Defender Office, which covers an area twice the size of Maryland. He worked with 5 counties in the region, Brewster, Culberson, Hudspeth, Jeff Davis, and Presidio, to establish the office and to address the severe attorney shortage in the area that the area was facing. After convincing 5 commissioners' courts that they needed to fund the office, he came to TIDC in 2017 for grant funding, which we promptly provided. The office was up and running faster than any other public defender office that we've helped establish. Judge Ferguson has been an innovator in other areas too. During the COVID pandemic, he was a trailblazer in using Zoom to get courts back up and running. That continued after COVID, allowing indigent defendants to more easily check in with the court and reducing failure to appear rates that were historically high due to the size of the region and the extremely far distances people had to travel to get to court. After the creation of the Public Defender Office, Judge Ferguson noticed that many defendants were showing up to court without counsel, even though they qualified for counsel. Many complained that they had requested a lawyer but were never appointed one. Applications for counsel took a long time to get to his court, and they went beyond the mandatory guidelines. So to solve the problem, Judge Ferguson collaborated with his court coordinator and Paul Chambers in the Public Defender's Office to develop an online portal for magistrates to quickly fill out, showing when requests for counsel were made, as well as to fill out an affidavit of indigency. The form is also available to defendants who are out of custody who want to request counsel. Requests are submitted, indigency determinations are easily made, and appointment orders are automatically generated and sent to all parties who need them after appointments are made. Appointment times have gone from about 10 days with the old system to about 10 minutes with the new system. Beyond his work in criminal indigent defense, Judge Ferguson also is involved in improving access to justice in civil and family law matters. He serves as a commissioner and executive officer of the Texas Access to Justice Commission and a commissioner on the Texas Children's Commission. For all these reasons, on behalf of TIDC, I am proud to present the Robert O. Dawson Indigent Defense Distinguished Service Award to Judge Ferguson. With the, he'll be the 10th person to receive this award. Congratulations. Let's go over here.
Oh, may I?
Would you want to introduce your family?
Sure. My wife Penny is here. She recognizes me a little. She sees me very little. My father, Robert Ferguson, is here from Houston. His wife, Leah Ferguson. And I'm going to introduce my friend. He's been my best friend since we were 10 years old. It is Dr. Rob Carpenter from Houston. The reason that I wanted to come and address y'all is because the gratitude that I have, it's all because of the people in this room that I'm standing here with this. And it started with you, because those of you who were in the room the first time I came here with nothing but frustration and an idea. And I launched it as hard as I could with the help of, and somehow everybody got swept up in it and saw the need, and it was funded just like that. And you've done it over and over again. Every time we come in and say, we have another idea. And y'all are right there, and you've made this happen. One thing I learned early on was the way to make things happen well is to identify people that share your passion and turn it over to. And I think that's probably a little bit of what you did with me, but it's exactly what I did with James McDermott. And this office would not be what it is if it weren't for James McDermott. So thank you. The system that was described to you was conceived by Paul Chambers. And Paul came over to my office and said, I have an idea. And I said, pitch it, just like you did to me. And he did. And after 3 minutes, I said, I think it's great. Do it. You have whatever you need from me. And so he worked with Lori. And if anyone deserves applause for this award, it is Lori Holguin right there. He is the absolute force behind all of this. She not only runs my 13 dockets in 5 counties, but all of my work everywhere else, and the commissions and the visiting judges. And she handles everything with everyone. What she does is incredible, truly astonishing. So I'm incredibly grateful for this. But this is not a reflection of me. This is a reflection of you and them and everyone who has thrown their passion together to try to solve a problem that has been ignored for the existence of West Texas out there. And I would put our system and our team up against anybody's in the room. Try me. So thank you again. Thank you for this unbelievable honor, and thank you for the kind words.
Thank you, Commissioner. Scott, your report, please.
Thank you, Judge Keller. Welcome, everybody. First, I would like to introduce a new hire, our newest fiscal analyst, Will Jones. Will? Welcome, Will. I wanted to report that our legislative appropriations request has been submitted to the Legislative Budget Board on August 16th. Per your instructions, we included 4 exceptional items to address the Fair Defense Account shortfall, establish an internship, fellowship, and loan repayment assistance program, to address attorney shortages, fund TIDC's Family Protection Representation Program, as well as add additional funds, $35 million to build more public defense offices. I will be testifying on September 9th before the LBB's joint budget hearing. We've been doing a number of legislative work groups, both on the criminal juvenile side of things. We had our second full board meeting, as well as second work group meeting, as well as a number of sub-work group meetings, as well as our family protection representation work group meetings and work groups. You will see the proposals that made it through the whole process during the policies and standards section. And regarding Operation Lone Star, arrests have been moderate in June, low in July, and they, I believe, continue to be low in August. El Paso, as we reported last time, there was an increase in arrests, and that has led the county to pass an emergency declaration, but they have not come to TIDC for a grant to pay for defense costs as of this time. And that's about it for me.
Thanks, Scott. Dr. Gamble. Yes, thank you.
Good morning. I have two things to report on. The first, under research. The State Bar of Texas conducted their annual attorney survey that focused on the economics of Texas legal practices. They concluded it in July of their year. And this year marks our first collaboration with them to help incorporate a supplemental questions for attorneys that took appointed cases. We asked about their approximate annual gross income from court-appointed work. And overall, the Texas State Bar received 7,178 responses, 490 which were from our kind of subpopulation of respondents. And we're currently working on analyzing these responses, creating descriptive statistics profiling attorneys that take appointed cases and their income in comparison to the general population of survey participants. So more to come on this. The second, which it's a blur, but it's been a lot of work, is this overhaul of the TIDC website. With assistance of the Public Policy Research Institute, continue this process. We are getting the 2024 reporting ready with 2 reports that will be on our new website, the Indigent Defense Expenditure Report and the Attorney Practice Time Report. This month, as we prepare for this launch, we've had both internal TIDC testing with this. We've had folks in counties, thanks to Jim, who got some folks to also come along. We got some great feedback from folks in counties, catching, little errors, but also just this could be, written more clearly, help us in this area. And so one of the many features to this website is kind of the user-friendly platform. So you'll see on page 21 and 22, just a PDF of this. The one on 21 still doesn't look like it came out right. But, this user-friendly platform, we're gonna kind of guide folks through. They're gonna have different colored checklists to let them know what they finished, what they need to continue working on. And then when it's all done, they'll have a nice submission button. So we're excited about this. Training for this is gonna begin for us next month, which is like next week. And we're ready for it. We have several trainings prepared. And then Edwin's gonna talk about just briefly some of the updates in the manual. We've kind of just helped the manual guide folks along through this new process, as well as some other things. So that's it for me. Thank you very much.
Thank you. Edwin's gonna talk later or not?
I think we'll get to that item later, Judge.
Okay, sorry. That's okay. Judge Maderi, are you here?
See Missy's iPhone.
I'm happy to.
Hi, guys. Can you hear me?
Yes, thank you.
Okay, sorry. I took time off today to do this meeting. I'm out of my trial and our house electricity just went out. So now it's flickering, kind of coming in and out. So I'm just going to try to listen in, and Edwin, if you can take over for me, that would be great.
I'd be happy to, Judge. If I can direct your attention first to some of our regular budget updates on page 23 of your meeting materials. The first item here is a revamped revenue analysis. Each board meeting, we provide you with an update on inflows into the Fair Defense account. And you can see here that we've simplified this because I think it was everyone's least favorite page in the meeting book because it was hard to read. So we've shown you the kind of annual recent history of inflows into the Fair Defense account. So that you can see the trends and then also what's been happening to our juror pay. So the highlight here I'd point out to you all is the YOY's year over year change in both dollars and percentage terms for each of these elements that flow into the account. So overall, it's up about 2% over last year. That's good news. You know, with the funds took a dive in the COVID pandemic and it's been slowly kind of creeping back, but not where it was. So that's good news. However, the bottom part of this page 23 shows you what happened to our juror pay revenue, which we've talked about. It was usually around anywhere from 6.5 to 6 million, and then it just went away. And we did get some this year that was 1.9 million. It was a delayed transfer from previous budget years. There was a problem at the comptroller in terms of getting those funds to us, but we just don't anticipate that juror pay coming in anymore. So that really kind of gives you a sense of the Fair Defense account revenue and really how juror pay is responsible for the shortfall that we're experiencing now. Page 24 is just a report on some of our previous budget years that still have active grants and activity. And then page 25 is just our regular financial activity to date for FY 2024. We still have not that much money that's gone out the door because it's really, there's a bit of a lag time because of when the grant payments get issued, and we're just about to get the formula payments processed. So those numbers will change quite dramatically before next meeting. I'll spend a few more minutes on page 26 though, which is a budget analysis that shows you, and this is an updated version of budget analysis I shared with you at the last meeting. The first two columns on the page 26 form reflect our budget with the amounts that were appropriated to us in the state budget. And then the last two columns, and that's for 2024 and projections for 2025. The last two columns on this page show what happens to our budget when we adjust to the actual amount of Fair Defense revenue that we have access to. And so while we were in the green, if we just went on with our appropriated figures, we're experiencing a shortfall because of that revenue that's not coming in from juror pay any longer. So the second to the last column on this page shows how we've been coping with that shortfall. We cut the formula grant this year to 17.5 from 20.5 million. And then we really just tapped the brakes on making new improvement grant awards until we get more clarity and predictability about our inflows. So if you look toward the bottom of the last two columns, you see that just based on these estimates and where we stand, we're a couple $100,000 in the red for 2024, but we have 458,000 in the black for 2025. So that surplus for 25 will offset the shortfall for 24. So we have found a way to cope with the revenue shortfall, but it is impacting our ability to make new awards. If there are no questions, I'll continue on. Actually, I think we're going to go to Doriana for a quick update on the formula grant program.
Thank you, Edwin. If I could direct y'all to page 27 of the meeting notebook, I'm going to give it a quick update on our formula grant special conditions. The status of special conditions for FY 23 as of August 29th, there are 12 counties that are not in compliance with court activity reporting requirements to the OCA and do not have an approved action plan in place. TIDC and OCA staff are working to investigate any website issues and issue approval plans to any affected counties. The status of special conditions on FY 24 formula grants as of this morning. There is one county that owes us a formula grant program commissioners court resolution. That is Karnes County, and TIDC staff is working with them. I believe we're getting it on the commissioners court agenda, so we should close that out really soon. And we have 83 counties that are not in compliance with court activity reporting requirements to the OCA. And we are currently working with those counties as well. Any questions? Perfect. If we could move on to page 28, I want to give a quick update on the formula grant request for applications. Each year, TIDC issues a request for applications, an RFA document for the formula grant program. The draft FY 2025 RFA has been updated with new dates and no substantive changes have been made. The draft FY 2025 formula grant RFA can be viewed if you visit the link on your email or in this book. We did include the formula grant calculations on the page. And there is a recommendation for motion number 2. I'm happy to read that. Okay. Is there a motion to adopt the FY 2025 formula grant program budget of $17 million and issue the FY 2025 formula grant request for applications?
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thanks. Edwin?
Good. Thank you, Doriana. Next, I would draw your attention to a series of housekeeping matters on page 29. I'll just go through these quickly, but feel free to stop me with questions. Page 29, we have a request from Travis County for a no-cost extension of the grant term on the final year of their award for the new public defender and managed sign council enhancements. Grant to Travis County. They are proceeding with a program evaluation. They'll be working with Public Policy Research Institute at A&M to conduct a study of the impact of our grant program. However, that program, because of PPRI's timeline, and that program's not going to wrap up until the end of 2025. So they're just asking for more time for the budgeted amount there through the end of, through December 31st, 2025 to finish the grant term. And we have motion number 3, which is to approve a no-cost extension of the grant term for Travis County Grant 212-24C13 through December 31st, 2025 for the limited purpose of completing the program evaluation.
Your motion?
So moved.
Is there a second? Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thank you all. Next item on page 30 is a grant modification for Victoria County for their Indigent Defense Coordinator Program. We awarded them an IDC grant in FY 23. The FY 24 grant includes a 40% county match. They're in the second year of the program. The county commissioned a big countywide study of compensation, classification and compensation study. And as a result, they took action on a countywide level to increase their salary. And so they're asking for an additional $3,796 for revised award, like $30,057. Have motion number 4, which is to increase Victoria County's 2024 improvement grant by $3,796 to a revised award of $30,057.
The motion? Your second?
Second.
Any discussion?
Was this in line, do we know, was this in line with the county employees as a whole? It wasn't.
Yes, it was. So they worked with an outside consultant, the county, Victoria County, with an outside consultant to review all staff classifications. And then that consultant recommended some adjustments which the county adopted. So this is really how that one of those actions affected our particular funded position.
And I want to point out that this is easy now for us because of the work that the staff did on coming up with a system for deciding when we should grant requests for salary increases.
Exactly.
This is what we'll be seeing from now on instead of who gets 3,000, who gets 2,000, what's the difference? Yeah.
That's right. Yeah, we do have good guidance in place thanks to the policies you all adopted recently. We appreciate that.
Any other discussion? All in favor? Any opposed? Motion carries.
Thank you all. Next item, we'll probably slow down for a little bit on page 33 because we're bringing back one of the modification requests from the last meeting from Culberson County for the Far West Texas Regional Public Defender Office we've been hearing a lot about today. And one of the things that was left, we did act on all of the pending requests related to the continuation grant for that program at the last meeting. However, the counties did ask for us to consider increasing their, or rather decreasing their county match to 20% and having the TIDC grant fund 80%. You'll recall that our standard sustainability grant program policy is to provide 2/3 funding. So they were asking for us to make an exception in light of a number of unique circumstances that the 5 counties experienced. 4 of the 5 judges, along with Mr. McDermott, the chief public defender, were at our previous meeting and spoke with y'all. And I understand that y'all had some subsequent conversations after the meeting. So we're just bringing back this this request. The cost of approving the request is $170,361. It is accommodated in the draft budget that I've prepared for you. We are able to act on it if the commission so chooses. And we've summarized a few of the considerations that were discussed at the last meeting regarding why the unique circumstances of those counties might warrant making an exception here. And with that, I don't know if we want to have discussion, or Judge Keller, if you wanted to.
Let's go ahead with motion, then we can have discussion afterwards. There's no.
We do have motion number 5, which is to approve Culberson County's request to modify the required county match for 2025 to 20%, increasing the FY25 improvement grant for the Far West Texas RPDO by $170,361 to a revised total of $1,336,497.
Is there a motion?
So moved.
Is there a second?
Second.
Any discussion? I want to just say that I was reluctant about this in the first place because I thought if we change the funding for this public defender's office, we're going to be getting requests from other public defender's office. But in the meantime, the staff has pointed out the difference in this and other offices, and I think this is an exception, and I think we ought to grant it, partly because it's such a big area with such a low tax base. And the other thing is Mr. McDermott and the other people in Far West Texas have done everything they can to make this a sustainable program. And I am afraid it's going to fail if we don't fund it, and I don't want it to fail. And they really have done everything they can before they came to us. So I just wanted to put that on the record. All in favor? Any opposed? Motion carries.
Thank you all. A couple of other quick housekeeping matters, and I'm going to refer next to a supplement. For those of you in the room, it is printed on green, just a few pages. A couple of additional grant modification requests. If you're following it online in Bovenda, you'll see these documents, this document in there. The first, these are both for Bexar County for the Managed Assigned Counsel Program. And there are 2 modification requests, quite minor. The first one is to extend the term of the Bexar County grant 21222 D0119 for the Managed Assigned Counsel Program through September of this year. It was originally extended through March 31st. They have some lagging expenses that are eligible, and we'd like to allow them to make use of those grant awarded funds. So we have motion number 6, which is to extend the term of Bexar County's grant 21222 D0119 for the Managed Assigned Counsel Program through September 30, 2024.
And when I need to abstain on this.
Thank you, Jim.
Is there a motion?
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thank you. Our last item on modifications is at the bottom of the green cover sheet here, and that is Bexar County requests an adjustment to this grant to reclassify for the Managed Assigned Counsel Program to reclassify 2 part-time office assistants to full-time. This reclassification is necessary to adjust to business needs for voucher processing associated with the implementation of a new vouchering process in Bexar County. The net result is to increase the award for 2025 by $2,817. So we do have motion number 6, which is to, motion number 7, which is to increase Bexar County's FY25 grant 21225 CO2 for the Managed Assigned Counsel Program by $2,817 to a revised award of $466,526.
Edwin, I need to abstain on this one too.
Okay,
Thank
is
you.
there a motion? Is there a second? Any discussion? All in favor? Aye. Any opposed? Motion carries.
Thank you all. Next item is on page 40, and we're pivoting now to several continuing improvement grants that we did not act on at the June meeting. Page 40 is regarding a request from Refugio County for a continuing sustainability grant request. The county request, so Refugio County is joining the Crossroads Regional Public Defender Office that is based in Victoria County. We have funded that office. They are not yet up and running and taking cases. Refugio County had been working with Texas Rio Grande Legal Aid, now Texas Rio Grande Public Defender, for their services. And what they've asked us to do is just extend their arrangement, their contract, funding for their contract with Texas Rio Grande Public Defender at least until the new Victoria-based program is up and running. They would also like to have us consider continuing that contract beyond when the Victoria office is up and running to operate as a conflict defender program. There are a lot of unknowns about the particular caseload need for conflicts once the Victoria office is in place. So what staff is recommending here is to award a 6-month grant that will allow them to continue their Texas Rio Grande contract for the next 6 months, which will allow them to continue to use that program. And in the meantime, to work with the stakeholders to do an analysis of the conflict caseloads. We do have motion number 8 regarding this, which is to award a 2025 improvement grant of $45,743 for the public defender program for a 6-month term. I also want to note that I have discussed the 6-month proposal with the county judge and Texas Rio Grande. Everybody agreed that it was a good way to proceed.
Thanks. Is there a motion?
So moved.
Is there a second? Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thank you all. Next item on page 44, this is for Willacy County, and it's also a continuing sustainability grant that we didn't take up at the last board meeting. However, this is a different circumstances. So Willacy County has been contracting with Texas Rio Grande Public Defender, previously TRLA, for since 2009 for their regional public defender services, and it's been under our sustainability grant program since then. They've decided to end their contract with Texas Rio Grande effective March 31st and will no longer be participating in the sustainability grant program. So they have reduced their continued grant request to only cover 6 months of public defender services, which will be an opportunity for an orderly transition where Texas Rio Grande can wrap up the cases that are in the pipeline and the county can begin to go back to their revised wheel system. So we do have a motion number 9 on this, which is to award Willacy County an FY25 improvement grant of $186,089 for the public defender program for a 6-month term. This would be the last sustainability grant for Willacy.
Is there a motion?
So moved.
Is there a second?
Second.
Any discussion? In favor?
Aye.
Any opposed? Motion carries.
Thank you all. Lastly, for grants, we have a couple of requests for compliance assistance grants, as they used to be known. We've kind of folded. We used to have a category of grants called compliance assistance grants that have been sort of folded into our general improvement grant program in terms of the application process. Both of these apply. The next one is also for Willacy County, and it is a request for an indigent defense coordinator. This request originated from EIDC policy monitoring, which identified some significant gaps in the processes in Willacy County regarding access to counsel. And our policy team did recommend to the stakeholders in Willacy that a dedicated indigent defense coordinator was really necessary, especially with TRLA or TRGPD as it's now known, not involved in the process and in the jails regularly assisting in the screening of defendants. There's going to be a very big procedural gap in getting defendants properly screened and appointments made in a timely manner. So because this is a mission critical compliance issue, we are recommending that the board proceed with an award here. And we have motion number 11. Sorry, we got a little bit, I got off pages. Motion number 11, award a 2025 improvement grant of $45,846 to Willacy County for an indigent defense coordinator position.
The motion?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Thank you all. Sorry that I skipped over another one on page 46. I would ask. 46 for Maverick County. This is a similar request, also related to compliance issues that have been part of TIDC's longstanding policy monitoring activity in Maverick County. I think Joel could regale us for hours about his looking at Maverick County and trying to help get them into compliance. I think they will benefit enormously from an indigent defense coordinator to address some of these gaps that we've been confronting in policy monitoring for a long time. So we are recommending motion number 10, which is to approve a 2025 improvement grant to Maverick County, $68,000 for the Indigent Defense Coordinator Program.
Is there a motion?
I'll move.
Is there a second? Any discussion? I want to say, I think this is great. All in favor? Aye. Any opposed? Motion carried.
Thank you all. The last thing I'll note for your information on page 56, we have a list of as you know, we've talked a lot at the last few meetings about our revenue shortfall, particularly impacting our ability to make any new grants. We've obviously pulled forward because some funds have become available as we've closed out some grants. We've taken some action on these smaller items, but we have a number of other grant applications that came in this year that we are going to be revisiting as the dust settles on 2023 and 2024, and as we work with the legislature to get additional funding. So we have those listed here. There for the PDF version, there's a link for you to review all of these applications in detail. We do believe that many of these programs are worthy of your funding and attention. We just have to hit the pause button on big new projects at this point and see where we stand moving forward. So we will be leaving these pending and bringing them back to you as our budget situation develops. And lastly, for my section here, I direct you back to page 57. This is the same budget analysis that I shared with you earlier in the meeting, but we're circling back to it here because the rightmost column of this budget is the staff's recommendation for a budget for you all to adopt for 2025 that takes into account the revenue shortfall. And so we do have a motion number 12, which is to recommend the 2025 budget with revised 5073 revenue as it appears in the last column on page 57 of the meeting book.
Is there a motion?
I'll move.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Aye. Any opposed? Motion carries.
Sarah mentioned the IDER manual when she was reporting, because of course, with our website redesign, we have to update our indigent defense expenditure report instructions to help counties figure out all the new things. So we don't have that manual quite ready yet. We're working diligently to get it finalized. But I just want to summarize for you that there are no substantive changes that have not already been presented and discussed and approved by the board. Some of those changes included an optional PD staffing report. We also have reviewed with you that we're eliminating the unused administrative expense addendum. It was sort of a unnecessary component to streamline it. So we have detailed guidance on the new website. We have also worked with OCA to collect a new report that they are statutorily required to collect on interpreter spending, separate from the IDER, but we're collaborated with OCA and are sort of piggybacking that new report onto the IDER, if you will. So the manual will address all those new things, but beyond that and other items that we've discussed with you previously, no substantive changes. So we're just asking for a motion to direct us to publish that updated manual. That is motion number 13 to publish the updated FY24 Indigent Defense Expenditure Report Manual.
Is there a motion?
I'll move.
Second. Any discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thank you all. We'll turn it over to Deborah for the fiscal monitoring report.
Good morning, everyone. The fiscal monitoring report can be found on pages 59 to 65 in the meeting number. Here I've got a list of the activities for the meeting, just to summarize. Since the June meeting, as far as new reviews go, I traveled with the policy team to Denton County. I conducted that review and it's ongoing at this time. As far as reports going out, we issued the Ector County report. That report was issued with the policy team report, and we are currently working. We've got a scheduled meeting on September 10th to go over all the findings with the county on that date. So we're working on a presentation for that. And then additionally, I had 5 counties submit their comprehensive annual financial reports and single audits. I reviewed them. I did not see where any of these 5 counties had TIDC funds selected for the single audit review, and I didn't really see anything concerning on any of those, so I just like to look at those. Anyway, that concludes my report. And,
Thank you.
okay.
Next. Improvement team report.
Thank you, Judge. Good morning. We have a very quick improvement team report this morning. Linda and I are continuing to handle the improvement team's duties for Operation Lone Star and have been working closely with Edwin and Chris Bound on the grants team, as well as our partners at Lone Star Defender's Office, Texas Rio Grande Public Defenders, and Neighborhood Defender Service. As Scott mentioned earlier, the cases coming in are within the capacity of LSDO between their panel attorneys and Texas Rio Grande Public Defenders and Neighborhood Defenders to handle those individuals and provide effective representation to them. Our planning study process, we have received several inquiries from counties that are in the early stages. We're also taking advantage of the rework on our website to look at opportunities to automate the planning study process, provide more resources to counties that are in the early stages of exploring public defender's office and managed assigned counsel systems, and to leverage the new website to provide additional staff capacity and more detail to counties when we do formal planning studies. In addition, we provided technical assistance to several of our new public defender's offices this month. We have been, or this quarter, we've been working closely with High Plains Regional Public Defender's Office as they're working with their host county auditor to get programs in place, their HR department to get their positions posted and get launched. We've also worked closely with Crossroads Regional Public Defender's Office and with Atascosa as they've been working with their board, looking at their salary adjustments and how to proceed pursuant to the needs of their county and trying to achieve parity for their staff with the prosecutors in their counties. For the Future Indigent Defense Leaders Program, we have selected our 5th class and notices have been sent. That class will have their 2-week boot camp program in October, which will happen immediately following the 4th class going for their returner weekend. In addition, our partners at Texas Criminal Defense Lawyers and Gideon's have developed an opportunity for our Fiddle alum who have graduated from the program, and also for attorneys in Texas who have completed the Gideon's program to have the option to come back at their expense or their office's expense for one night's hotel, a dinner to build community, and then participate in some of that training as well. So we're further leveraging the state grant dollars and building the community that Fiddle has created. And then we also had the inaugural version of our new officials and TIDC newsletter go out. Many of you received that earlier this month. This first edition was focused on the website updates, talking about trainings we'll be doing for the indigent defense expenditure reports and for the attorney percentage of practice reporting, and providing more detailed information to our county stakeholders to assist them in the process and provide them contacts with the IDC's team. Kristen, would you provide us an update on our work with law schools and the recruitment initiatives?
Sure thing. Thanks, Bill. So we are the end of August and the beginning of September, which means law schools have started back. So all the students are starting back in their fall semesters, and we have been busily working with their career services, with law student organizations, and with the Texas Criminal Defense Lawyers Association to put on public defense days this fall at law schools throughout the state. We have 6 currently scheduled, and we may have 1 more that comes out, we'll see. And so we'll be going to those schools and hosting panels of public defenders and private counsel who take appointed cases to show them how they can get involved in this work, to show those students what opportunities lie here, both as a full-time public defender as well as in private practice, taking those appointed cases in that form. So we're working through that right now. We're getting all those logistics finalized. We've also started reaching out to public defense attorneys and public defenders, inviting folks to come be part of those panels. So we're working out those lists right now. And I did want to do a big shout out that I am not doing this alone, which is awesome. I love having help and I love the fact that it's not just me. It is a lot of logistics, so a big shout out to Demetri Brown and our staff, and then Ashley De La Garza for really helping us pull this together. And we'll be traveling across the state in September and October.
Policies and standards, Mr. Bennett.
Thank you, Judge. So policies and standards met last week and we voted on a number of items. So we have a bunch of committee motions, which means both Judge Keller and I agreed. Makes it simple. You have. So the first item involves Dallas County, and Joel, can you explain where we are on that?
Yes, sir. If you could, please turn to page 68 of the meeting notebook. Commissioner John Wiley Price from Dallas County requested that TIDC conduct a limited scope monitoring review of the county. And his request asked us to look at some things that we don't normally look at currently. And one was capital case appointments. And the second was whether the county was meeting the public defender priority appointment statute. We issued the report, and that is on pages, it begins on pages 71. The report made 3 findings, all dealing with capital case appointments. And the first finding found that Dallas County did not always appoint 2 attorneys when they appointed private counsel in capital cases. The county doesn't have to appoint 2 attorneys if it appoints the public defender office or if the prosecutor makes a written notice that death is off the table. The second finding was that Dallas County did not always make written findings of good cause for appointing private counsel rather than the public defender. And the third was that in capital cases, sometimes attorneys were appointed who were not on the regional appointment list. Dallas County responded to the report. For the first finding dealing with 2 attorneys, they noted that they have not had a death penalty case since 2015 and the current DA is opposed to the death penalty. They stated that they will follow the Article 26.052 requirements, but if strict adherence is expected, they want us to notify them of that. As to the second finding, dealing with written findings of good cause, they were in agreement with our finding and they were committed to following the statute. As to the third finding, dealing with appointing attorneys who were not on the regional list, they noted that they do not have to do this if death is not on the table. But they also stated that the judges are fully aware of their responsibilities and are dedicated to making appointments that align with the statutory requirement. So we weren't quite sure where they stood on this actually. So we have to reply now to them. And on pages 70 and 71, we have a two-page letter. And basically it asks them to outline how they will follow the Article 26.052 requirements for appointing 2 attorneys and asks them to clarify their response with regard to finding number 3, that is the finding about appointing attorneys who are only on the regional list. We discussed this at the PNS meeting on August 19th. We had input from 2 Dallas County stakeholders, the local administrative district judge, Judge Huff, and the staff attorney for the district courts, Christine O'Neill. As Mr. Bunden said, we discussed this and the committee passed a motion for us to send the letter that is listed on pages 69 and 70. And so these are somewhat novel issues, and so we're bringing it before the full board. And I believe we have a motion for the full board to pass us to send this letter.
Yeah, so we have a committee motion which needs no second. Is there any discussion of this item? Basically, we're sending them a letter saying follow the statute. Okay, no discussion. All in favor? Aye. Any opposed? Then it passes. Okay, next item is we have a committee motion to publish the proposed policy monitoring rule amendments and rule review. Who's doing that?
I'm doing that.
Okay, Wesley, thank you.
It's Mr. Budden. I direct your attention to page 104 of the meeting book. And this is to do with the requirement in state law that all agencies must review their existing rules every 4 years and republish them, and propose amendments as needed, but they have to be published every 4 years for public comment and then readopted. The policy monitoring rules were last adopted in 2020. And so we've gone through them and reviewed them and have some suggested amendments to the rules, which is, as you noted, were taken up by the committee last week. If approved by the full board, they'll be sent to the Texas Register through the Secretary of State's office for publication. They have to lay out for 30 days, and then they're eligible for adoption by the board. That likely will be at your next meeting on December 6th. There could be comments that would have to be reviewed as well at that time. So I have a summary of the rules. I'll run through those starting on 104, but the actual amendments of the rules themselves start on page 106, and the substantive amendments don't begin until page 108, which is where I'm going to start with the summary. The first changes are to the prompt appointment of counsel section. And this changes here would require the monitor to make a finding of the court if it finds the court did not explain the procedures for requesting counsel to unrepresented defendants, or identifies cases in which a defendant is entered an uncounseled plea while having a pending counsel request. This really tracks our current process in these cases. The next set of proposed changes are to the attorney selection process. And these really flow from that Dallas review we just did. And so the first one, which isn't capital related, but it is similar, is related to the public defender priority appointment statute. That's in 2604F of the Code of Criminal Procedure, which requires the courts to give priority to appointing any available public defender office with some exceptions. And so the proposed change would have us actually review those. We haven't done that in the past. Next, in counties that had a public defender's office that actually accepts capital appointments, and at the moment, I think there's only 2, Dallas and El Paso, the monitor will verify that the office is appointed in each of those cases. And if it's not, we'll determine whether the court or its designee made a finding of good cause on the record, which is required under 2604 F1. And next, if in capital felony cases where a public defender office is not appointed, the policy monitor will determine if 2 attorneys were appointed and whether at least one was qualified to serve as lead counsel on the local selection committee's list under 26052E. And if only one attorney was appointed, the monitor will determine whether the state had filed a written notice that it is not seeking the death penalty and the date that notice was filed. The next change would be to the report issuance section, D1. And it would require that staff submit draft policy monitoring reports to the Policies and Standards Committee rather than to the county for review within 60 days after we receive all the data that's necessary to complete the review, rather than 60 days of a site visit. And so there's really 2 parts to that amendment. And the first one is that the review process can sometimes take several weeks if there's novel issues and there's changes that are needed to the report after the Policies and Standards Committee reviews them. And the second part is really because monitoring reviews, some of them are now fully remote. We can do, for instance, case file reviews and limited scope reviews remotely. So there's not really a time frame to bounce off of that 30 days or 60 days rather. And sometimes we have delays in getting data. So we may go on site, but it might take 3 months or more. We've had some issues in Potter County, for instance, getting data. So that's why we're proposing shifting that time frame. The next change is to failure to respond to a report. That's in subsection D4. And it would change to require formula grant payments rather than all grant payments be withheld if the county does not respond to a policy monitoring report within 10 days of receiving a certified letter notifying the local officials. This process is very rarely comes to this. Typically we get responses, but we want to assure that improvement grant funded programs like public defender offices aren't immediately jeopardized for failure to respond to a report. And the last change proposed is to the non-compliance section in D5. And it would specify that the commission can require regular reporting of data to determine if process changes are being implemented and their impact on compliance when the county fails to come into compliance with findings for several reviews. Currently, the only process specified in that rule is to take administrative action to impose a remedy for noncompliance, such as withholding grant funds. So We have taken on a case-by-case basis and would still do it on a case-by-case basis. And this reporting step you're about to hear in the policy monitoring report, that is actually what's happening right now in Maverick and Zavala counties following up on monitoring. So with that, as Mr. Bunnan noted, there was a committee motion to publish the proposed policy monitoring rule amendments and rule review in the Texas Register.
Okay. Any discussion? All in favor?
Aye.
Aye. Any opposed? Passes. Okay, now, Leslie, you're gonna explain all of our legislative. Well, the overview.
The policy at least, yeah, the overview. So yeah, next we're talking about legislative recommendations and how those come to be. I'm gonna just touch on a couple of things from the legislative policy, which begins on page 111 of your meeting materials. You'll know, have the authority to make recommendations to the legislature under the authority given to the board by section 79035 of the government code, which is excerpted there. So there is a provision for those to be included in our annual report and made for the legislature. Somewhat unusual for a state agency. There's a lot of details to the process, but the key one for today's business is on page 112, which is approval of legislative proposals by the commission. And that's in subsection B, which basically says that the commission has to agree by a 2/3 vote of commission members present and voting at the meeting at which they are to be considered. So that's today's meeting. We'd have to have 2/3 vote for any proposal to be considered. Turning now to the actual work groups, Bill and I are going to cover the legislative proposals from the criminal juvenile group, which is the one we've had historically over the years. Page 114 has the background on that group met twice in this room, May 30th and August 6th, as well as on Zoom. I think we had the best participation we've ever had. There were also a number of sub-work groups working on individual proposals, but the list of stakeholders is on the bottom of that page and the next page. This is the actual members who attended. So it was very few people who we invited who did not attend. I don't believe ever had 4 judges attend these meetings, and that was just all really good given their input, as well as all the typical stakeholders, our county friends, court administrators, indigent defense coordinators, public defenders, defense attorneys, as well as a number of legislative staff and staff from the speakers and governor's office who attended. And with that, I think we'll turn to the proposals. Page 116 has a listing of all of the proposals that are before you today from the criminal and juvenile legislative work group, as well as their status after the Policies and Standards Committee meeting last week. You'll see that a number of them are recommended for your approval, agreed to by Judge Keller and Mr. Bunnan. And then there's some that they have sent forward to this full board to consider today. So with that, I'm going to briefly, yeah, I'm doing the first one, and then Bill gets a lot of them. The first one, which starts on page 118, would specifically provide in statute for a limited scope attorney appointment to represent an arrestee at a 1517 or magistration hearing. And this is a provision that was before you before, and it actually did go to the legislature as part of the TIDC Omnibus Indigent Defense Bill. And there was some concerns raised by our county friends that they were concerned that without this could result in judges making appointments in these cases, setting up a whole new system of appointments without any input from the commissioners court, even though the commissioners would be obligated to fund this new representation, which, to be clear, isn't required, but a number of counties have chosen to provide representation at these hearings. So the proposal is basically the same, except it does add a clause, which we actually highlighted, that these appointments can be made if the commissioners court approves funding for them. So that was the change that was made at the work group level. This was a consensus. There was no opposition to it. And there is a committee motion to approve legislative proposal number 1.
Okay, any discussion? All in favor?
Aye.
Aye. Any opposed? None. Okay, passes. Bill, take the next one.
Proposal number 2 deals with a lot of cleanups in the MAC statute, and Also 2605 C, dealing with when or if a MAC director can have a designee authorizing payments. Working through the MAC statute, it adds a clarification that MACs are performing a delegated judicial function. It specifies the areas for which a MAC may be used on the definitions, including for appointing or providing investigators, experts, or other support services for appointed counsel and their clients. Clarifies that MACs can have the process of approving vouchers for payments for attorneys, investigators, experts, and other reasonable expenses to effectuate the legal representation, and also for the oversight of the quality of representation provided by the appointed counsel. There's additional clarifications in the managed assigned counsel or MAC plan of operations, which must be adopted to govern how the MAC program runs, that it has to describe the circumstances under which the program may appoint counsel providing representation in ancillary or collateral matters to effectuate the constitutional right to assistance of counsel. This has come up in the case of DWI charges where there may be a compelling need for counsel to provide representations in the administrative license revocation hearing or in family violence cases or other assault cases where there may be a protective order to provide representation in the protective order hearing. But that would have to be in the plan of operations and then approved by the county that is creating the managed assigned counsel program. The policy also should include circumstances under which an attorney can withdraw from a case, what good cause is established for the MAC program to remove an attorney from a case, and if the MAC were to remove an attorney, what the procedures would be for that removal. And then one item that was added to this through the work groups was addressing a concern to actually the second MAC proposal, but came back to this because it's in the plan of operations that came from Bear County, dealing with adding MAC access to juvenile information, that if MACs do have juvenile information, their plan of operations would need to clarify who has access to that information and under what circumstances it may be used. The other change dealing with the replacement of counsel is specifically how that notice must be given if a MAC is replacing counsel. And then one item to deal with the challenge that Harris County has run into. The current MAC statute 2605C says the MAC director may approve payment of vouchers. However, they've run into an issue when the director is out of office for whatever reason, that their reading is it did not permit the director to designate another member of the staff. So this specifically allows a designee to do that in the director's absence. And on this bill, we do have a committee motion or this proposal, which would be to approve legislative proposal number 2.
Any discussion? All in favor? Aye. Any opposed? Okay, passes.
For the second MAC proposal, I'll go through at a high level. The detail is included in the board book, but it adds specific authorization for a MAC program to access juvenile information under the same circumstances when an attorney would be authorized to access juvenile information, either with the juvenile probation department, prosecutor's file, or with the juvenile detention files, dealing with issues that come up when a MAC program may be appointing counsel. Based on concerns from Bear County, it was revised to limit that access to only once a request for counsel is made if the MAC program is going to be appointing counsel, or if it's not assessing indigence once it's making the appointment to assess indigence or other potential conflict issues.
Yeah, and I think right now we're the only jurisdiction that is overseeing the juvenile side with the MAC. I had wanted to set up a meeting with our 3 juvenile court judges to kind of walk through it because their general administrative counsel had called in on one of the meetings and expressed some concern. So this does have a committee motion But if we could possibly table this until December, that way I'll have an opportunity. I think the in it is good, it's solid. And if other jurisdictions do adopt a MAC for juvenile, I think it would be helpful. But so I would just request if we could table this until December, since we're the only jurisdiction right now that this would impact.
If there's no objection, I guess that's all right. You need a motion to table it?
Yeah, we have a
I'll
committee
move
motion.
ta-
I'm not
I'll move
sure.
to table it.
That sounds great. I think Judge had research.
Yeah, I'll second that. All right. Okay, so next.
Next is proposal 4, and that's me, Mr. Bond.
Yep.
And that begins on page 134. This is a proposal that came to us from Ted Wood from the Harris County Public Defender's Office. Mr. Wood is here. Available to answer any questions if they come up. This would make staff and public defender's offices and managed assigned counsel programs home address information confidential in tax appraisal records, or at least make them allowed them to make them confidential by approaching their tax appraisal district. So currently, appraisal district records are public, and it includes the address, home address of the owner of each property in the state. And there have been instances, which are detailed here, where public defenders have been approached and threatened because of their work on specific cases. And there's, some concern about those threats and the need to keep their addresses confidential in some cases. Statute already allows for confidentiality for a number of different types of individuals, including lots of justice officials like judges, probation officers, district and county attorneys are already covered under this, as are federal public defenders. So this proposal would simply add state public defender staff, as well as those in managed assigned counsel programs. And that second part was added during the work group process. There was no opposition to this. And so there isn't a committee motion once again.
Any discussion? All in favor?
Aye.
Aye. Any opposed? It passes.
Proposal number 5 begins on page 137 of the board book. This also comes to us from Ted Wood at the Harris County Public Defender's Office, who is here, as Mr. Shackelford pointed out. This deals with the fact that prosecutors' offices, either directly and or through law enforcement, have access to the Department of Public Safety's database of photographs for driver's licenses and Texas ID cards. And the request was to give similar access to investigators at public defenders' offices. We did have a sub-work group on this. We looked at 2 potential ways to phrase this, one being only a licensed investigator at a public defender's office, the other based on concerns in the initial work group meeting that all defense attorneys would have access to it. We reached out to DPS to get their insight several times. First, as we're doing the initial drafting, they drew our attention to the Federal Driver's Privacy Protection Act, which they initially indicated could be a source of concern, but then also pointed out that there is a carve out in the Federal Driver's Privacy Protection Act for a criminal defense attorney representing a client in a case. And they suggested to us that we reference that in the draft language. After we got the draft language prepared, we sent it back to DPS following our second plenary work group meeting. DPS got back to us, and a copy of their email response starts on page 140 of the board book. They were in agreement with our proposal that would limit it only to public defenders' offices. They expressed concern if it went to all defense counsel that it might have caused some significant fiscal impacts with requiring additional staffing. The only reason we did, I believe from the discussion at PNS, we did not have a committee motion was to get DPS's feedback, which we got several days afterwards supporting version 1.
So since the Policy and Standards Committee, that's when you got their agreement.
Their final agreement to version 1, correct?
We need a motion.
I'll move.
Second. Okay. Is there any discussion? All in favor? Aye. Any opposed? Okay. Then it passes. All right, next one.
Proposal number 6 starts on page 142 of the board book. And this is another one that came to us from Ed Wood at our second work group meeting. We had extensive research that Mr. Wood put together based on questions from the initial work group dealing with the extent of the current issue. This deals with the practice in some counties of a prosecutor including as a condition of a potential plea bargain that the defendant has to agree to repay the costs of appointed counsel without any respect to that individual's ability to pay. The change this would make in current law is that that cannot be a condition of a plea bargain, but it would still leave the existing sections of the penal code that allow a court after taking a plea to then not only can but must assess an individual's ability to pay before deciding whether or not to assess a partial or full reimbursement to the county of the costs of that appointed counsel. We had significant research from Mr. Wood and also a paper from Jesse Tyler, who's also here, laying out the structure of fees in counties. But again, this would not stop courts from assessing reimbursement of fees. It would only prohibit that being a condition of a plea bargain.
So, as I recall, we didn't vote on this at the committee. We just passed this on to the board. Judge Keller hadn't read all, you hadn't read all the materials and we didn't ask for a vote. We just pushed it on. So, Ted Wood is here today. Jessica Tyler is here today. I've asked Ted Wood make just a short presentation on his study and maybe the methodology that Jesse Tyler put together.
Want me to stand up here or?
You're
fine. Okay. At our first work group meeting on May 30th, there was a question raised about whether this is really a problem and whether this goes on. And so I asked for permission to do a little research project on that and bring that back to the second legislative work group committee on August 6th. And Jesse Tyler and I worked on separate reports, but we worked together on them. And I'll just say a minute about what my report is and my methodology, and then I'll ask if it's okay for Jesse Tyler to talk about hers for a minute. But what I did was reach out to people in the criminal defense lawyer community to try and find out if this was going on in their counties. And what I concluded was I found 65 counties out of the 254 where it's definitely going on. They tend to be mid-sized counties like Potter, Randall, Midland, that kind of thing. We don't see it very often in the larger counties. We don't see it in our own county, Harris County. We don't see it in Travis County. We don't see it in Dallas County or El Paso County. But we do see it in the mid-sized counties and a number of smaller counties. So I received feedback from defense attorneys. They would tell me whether this went on or not. For example, I received feedback from James McDermott from the Far West 5 counties, and he told me that absolutely not. It does not happen in any of those 5 counties. On the other side, though, I did receive a lot of input from attorneys who said, yes, this is standard operating procedure. It happens in all plea bargains. And so I've tried to document that. I've got like a 152-page paper where I go through the 65 counties. I have comments from the attorneys. I have 10 or 12 appellate court decisions that reference the practice, and I'm not sure, Bill, if this was given to members of this committee or not, these reports.
It was given to the Policies and Standards Committee,
Right.
not the full board, and that maybe.
Okay, so presiding Judge Keller is aware of it. Alex Bunnan is aware of it. I'm not sure if the rest of you are aware of it, but that's our report. It just is,
Maybe just describe what it is. What is the procedure that they're doing? What is
Oh.
happening?
Okay, so I think it's interesting. For example, have a judgment from Swisher County. I'm sorry. Yeah, Swisher County, that's Tulia. And copy of the judgment. It contains the following special orders or findings. And if you're familiar with what the standard felony judgment form looks like, this is something that can be added at the end. It says the court finds the defendant agreed to pay attorney's fees for trial counsel as part of the plea bargain. Accordingly, the court orders the defendant to pay trial attorney fees in the amount of $500. This is the kind of thing, if you will, that we're seeing happen in a number of counties across the state. And in my view, at least, this is sort of a take it or leave it proposition for the defendant. If the defendant wants to participate in a plea bargain, accept the terms of the plea bargain, I mean, this is one of the terms. You take it or leave it. It's kind of an adhesion contract. So that's what I'm talking about.
Yes, did you want to say?
So I kind of went in looking at the same question as Ted, but through a different source. TIDC, as I'm hoping most of you know, collect the amount expended on indigent defense provision within a year. And then there's also a line where they collect the amount of reimbursement monies that would come from these defendants repaying into the county system. So I got that for all 254 counties, hoping to kind of get some good suggestions from the data is where I should start looking. And so there's sort of two ways that I went into it. So first, just for everyone's edification, about 2% of monies expended on indigent defense resources are recollected in these chargebacks within a year. But if we exclude counties that collect nothing, and then also the 5 largest counties, which would have like a much larger, just by delivery mechanism, imprint of expenditures, and as Ted mentioned, they're not really collecting any of these monies. The chargeback is more like 5%, and that ranges, somewhere from 0 to 108%. So I first looked at the counties that are the highest proportion of reimbursed monies. These tended to be like much smaller, like 30,000 person counties, and they don't have all of their records online, the way that you would imagine you could look up like a Harris, Dallas, El Paso, like the Tyler Technology front-facing portal. So of the 108% county, I think they're just collecting the data incorrectly based on the info that I looked at. I talked to a lawyer that practices there. Looked at another county, Kerr County, they were at like 70%. I didn't see any record of indigence determination at plea, but I did find that they were doing the chargeback. So I kind of abandoned the largest proportion simply because there wasn't enough information and I wasn't trying to drive out to like random East Texas to throw files. But that's something for Joel in the future. And then I looked at counties with the 10 highest amounts, and these are like where Ted was going. So these are our kind of like McLennan, Randall Potter, Ector style counties. And so I started looking through their front-facing records and, did find, so for example, in Randall, we see, I found a record from a defendant entered a plea, was required to pay back the attorney fees. Those weren't assessed until a week after the plea had already been signed. So there was no record of the indigence determination. And so but these fees were assessed to that defendant. Not only were they assessed once, they were assessed twice. Now this woman owes double what was even paid to her lawyer because there was no lawyer there with her to talk through whether or not she could afford it or whether or not they should be incorrectly assessing them twice. And I also, but Randall has a lot of information online. They only issued one check to the lawyer. So it's not even that, that these fees were $2,000. It was, an error, which means that if she doesn't pay, then she'll, probably have to get another lawyer appointed. And so it just really seems like a situation where there needs to be hands-on from counsel. Another county in North Texas, and I just want to point out, it is possible that they are assessing indigents and not just recording it like within the record that I can access online. I also did not cherry pick this stuff. It took about, 5 minutes for each county to just look up lawyers I knew did a lot of appointed work. And another example from North Texas kind of shows this, which is at the county court at law level, fees are assessed. The payback is assessed, the indigence is not looked at. But at the district court level, where they also assess the chargeback, it clearly indicates that there is some record of looking at the person's ability to pay. So there's, a gap in, I'm not sure if it's like knowledge or just practice, but these records are all kept in the same system and there's, clearly this gulf. And then my third example, which this also, it just doesn't record any ability to pay. And I'm not saying that it did or did not happen, but there was a chargeback assessed and the person lived at an address recorded as 123 Transient Way. So I'm thinking that that person did not have, the $400 owed, for the reimbursement of counsel. So looking at what Dr. Gamble presented earlier in this meeting about the sort of retraining and then also what, Edwin, Wesley and Bill talked about with the new IDER manual. Some of my concerns I think could actually be redone through, and this is on data collection, getting the best data possible out of these counties to truly have the right information. So when y'all do desk reviews or, in-person indigent assessments for the delivery, the right information is there. It correctly reflects what's happening in the county. And you could go forward, but I also think that, where Ted is going with this is a way to just set a baseline of knowing that only the absolute correct reflection of law information is getting into the system because, you have that requirement for the indigents to be assessed from the bench. So that is what I found. It's all online. Or if you guys are curious about looking at some dashboard, but.
Thank you. Okay, so we need a motion for number 6, which would prohibit plea bargains requiring defendants to pay for their court-appointed attorneys without court approval.
I'll make that motion.
There's a second. Okay, is there any discussion?
Yes.
Yes.
I'm gonna vote against this. I'm gonna say why and try to make it brief. I appreciate the work that y'all have done. It's a lot of work and I really do appreciate it. I'm not sure this is a problem that we ought to be addressing. How much money was collected by lawyer defendants paying for their attorneys and how much total? Do we know last year?
Whatever that report is that we.
I think it's $8.5 million.
It's a lot of money. We are short on money. And I think a lot of defendants, it's a plea bargain. They're agreeing with it. And a lot of defendants can afford to pay some or all of their attorney's fees, even if they can't pay for investigators and everything else. I think I would leave it up to the judges. I would leave it up to the parties to establish their own plea bargain and not get involved in this. Thank you.
Thank you, Judge. Any other discussion? All in favor? Aye.
Aye.
It's 3. Did you vote? You're not voting? You're voting for? Or you're voting against. All right, so, okay, so how about on the, since this is gonna require numbers, we got Judge Evans, can we hear you?
No.
You're gonna be a no, okay. All right, we're not gonna have enough votes to pass, so.
I'm a no as well, guys. Judge Maderi.
Thank you, Judge. All right. Does not pass. All right, next is create a fund and a student loan repayment. Who's doing that? Scott.
That is me. So this is proposal 8A, beginning on page 145. This is a little different than the other proposals we brought to you in the sense that, the other proposals had legislative, language, drafted up. And, this proposal really is, it's just a policy, recommendation at this point that we still need to turn into, legislative language. The purpose of, this legislative proposal is to implement the LAR recommendation that the board has already approved regarding establishing an internship, fellowship, and loan repayment program. In order to really, make that possible, some additional legislation needs to pass. And so we were going to base that legislation on, Kristen, help me out. What's the doctor's repayment?
The Physicians Education Loan Repayment Program. There's other programs like it, like the mental health professionals, loan repayment program as well.
So there's the loan repayment component. There's also an open question as to whether or not we would need, legislation as part of that for the internship and fellowship program, or if we could just, use our existing grant program as part of that. So, today, we're asking you to, I guess, approve of this legislative concept. Between now and December, we could bring back some, actual language for y'all. We could just punt this, until December as well. To me, either way, it doesn't really matter. I leave it to y'all how you want to proceed.
Well, there's a committee motion,
There is a committee motion.
so
You can approve the concept and we can certainly bring back the language to y'all in December.
I'm good. All right, any other discussion on that? All in favor? Aye. Any opposed? None. It passes. Okay, ensure payment of expenses for attorneys to meet out of county jails.
That's me. So that's proposal number 10, beginning on page 147. This is a carryover from last session with an amendment that was approved at the work group level. It's to do with attorneys who have clients who are housed pre-trial in faraway jails. They don't have sufficient capacity in their local jails. And it becomes a real burden, especially in those counties that pay a flat fee to represent someone on a case, to actually take the time and expense to drive to wherever it is, to meet with their client. And consequently, a lot of clients don't get to meet with their defense lawyers. So this bill would require a county that does house pretrial defendants in another county to amend their plan to provide compensation in their fee schedule for reasonable and necessary expenses in having that communication with their clients who are held out of county more than 50 miles away from the court in which the case is going to be tried. And the addition that was implemented by the work group and why it's here for you to vote today specifically is that it provides also for the payment for the attorney fees for the time traveling outside the county from where the case is pending to meet with their client or do work on the case. And there is a committee motion.
Committee motion, so any discussion? All in favor?
Aye.
Aye. Any opposed?
I'm opposed.
Judge Evans, you opposed?
I'm opposed, yes, sir.
Anyone else? Okay.
I'm in favor of it.
He's in favor. I mean, I suppose we should, we're going to count in the room just to
We
be
have
sure.
6 votes, don't we?
Yes, well, yeah, we have 8 members. Is that right? Yeah, so we need 6.
1, 2, 3.
I'm in favor, Judge Maderi.
5.
I think we have enough.
Well,
we need to get Jim out of the restroom.
Let's come back to this then.
Okay.
Well, when Jim gets back. So, all right, what, we have one more? No, we're passing that up. ensure,
List, is it in the?
Well, because there's not,
Oh.
there isn't gonna be a motion. It turns out, is Judge Harl in the meeting room? I mean, we were gonna pass on that one, but I don't know why, he did decide to join, I guess, in case y'all had questions or.
I was told we're gonna wait on that.
I wanted to comment on it. Do you want to finish the?
The one thing we have to do are re-approve last
That's
session.
right. Mhm.
Okay,
Okay.
and there's a committee motion for that. So do we need to briefly describe what they were? Okay, all right. So there's a committee motion to approve all the ones that we had from last session, and any discussion on that? All right, all in favor? Aye.
Right.
Any opposed? Okay, passes.
Jim, let me just comment briefly on proposals 11 and 12. We voted on this, policies and standards, both of them. And if you voted for them, I voted against them. And I want to say why. Proposal 11 would create a committee, and the board, this board, would delegate to that committee the authority to set standards for capital murder cases and training standards and reporting standards. And my initial response was, I don't think our board, that is primarily majority judges on purpose, should delegate to a committee that is 2 judges and 7 non-judges the authority to do what we have not done ourselves. This issue, this kind of issue has come up before. A couple of years ago, totally by accident, there was a proposal, it was a proposal going to the Judicial Council that would have changed the balance of power on this board, make it majority of non-judges. I think it was totally by accident. And after talking to some of the people who worked on these proposals, I think it was by accident this time. I don't want this to happen, and I don't want it to happen by accident. So I think that we should look at revising our legislative policy to add a section that says that any legislative proposal adopted by the board cannot delegate the authority of the board to a non-majority judge committee or reduce the proportion of judges on the board. I don't want to do that today. I'm putting that out there as a way to ensure that this doesn't happen by accident, doesn't slip by, but also to save the time of the members of the legislative committees who have worked so hard on these proposals, and the staff and the board by not allowing those proposals in the first place. We're not going to do that today, but I hope we can do it in the future.
Okay, I see Judge Harrell's on the call. Can you unmute, Judge?
Yeah, I have no opposition to more judges on the board. As I said, we were kind of retooling what was already in existence on that other bill, but I certainly have no opposition to adding more judges. I think it would be good, and I would support that.
And let me comment, as far as the substance of the proposal, I agree with Judge Harrell that we need to do something about the lack of attorneys on the list to be appointed to capital murder cases. And I think we have to do it quickly, and I think we have to think about it really hard. So what we're going to do now is Scott is going to talk to the regional presiding judges. We're going to reconsider a proposal in December, but I think it is a critical issue for us to address. And the fact that I voted against this doesn't mean I don't think that it's not important. I think it's very important.
So this will come back at some point. Thank you, Judge. So we need to get Jim Bethke's vote on item 10, proposal 10, which was to ensure payment of expenses for attorneys to meet with defendants held in out-of-county jails. Okay, so we have a majority.
Well, we need 2/3 and we do.
We have 2/3 and
we've lost Reggie Smith, so we're actually at, we need 5 of 7. So yeah, to get to 2/3 and we have that. So
Okay.
there was only one against.
all right, so that passes. All right, so we have all our motions.
And the criminal and juvenile, yes.
Yeah, and so the next, we still have a couple items under policy and
The
standards.
family protection representation work group.
Oh,
Recommendations.
okay, let's do those. And
That'll be Crystal.
okay. You wanna lay that out?
Yes, thank you, Mr. Brennan. On page 179 of the meeting book, you will see the list of attendees to the meetings. As you all know, we have never done family protection representation legislative work groups before. This was the very first time. So it's an exciting time to even be able to talk about some of these things and start addressing some of the systemic issues that are in the system. The group met on August 19th in a hybrid meeting, and then again on August 29th. We had multiple sub-work groups between those two meetings and a lot of really great engagement. The list of people from page 179 and 180 are all the people who attended at least one meeting, either a large work group meeting or a sub-work group meeting. So I think we had really great engagement considering this was the very first time we've ever done this. And we also got a lot of different perspectives from different people who work in various parts of the field. So on page 181, you will see the list of, we've got three proposals to bring before you here today. None of them have a committee motion, unfortunately, but we're still glad to bring them to you all to consider and think about. So the first proposal, you can find that on page 182. So this is essentially a cleanup bill. Texas Government Code Section 79.0365 requires that TIDC collect fee schedules from counties every other year about their family protection representation fee structure. So we've done that now for 2 years. Actually, 2 years ago, we did that on behalf of the Judicial Council, and this year we did it just for ourselves. And in our data collection efforts, we learned that there are a lot of inconsistencies in the fee schedules that are being used for family protection representation. And then when we dug into the law further, we realized it's probably because the law is extremely unclear on what's required for fee schedules for family protection representation. The current law is found in Texas Family Code Section 107.015C. That specifically mentions that attorneys that take these appointments need to be paid by a fee schedule. But then it directs you to Chapter 51 of the Family Code, which is the section of the Family Code that deals with juvenile delinquency cases. And then the law then routes you over to Article 26.05 of the Texas Code of Criminal Procedure, which does specifically have rules about fee schedules, but those rules are only tailored to criminal cases. So that's where the law gets extremely confusing. And what we've seen from some of these fee schedules is some counties don't even have one. Some only send over their criminal fee schedule, which is completely inapplicable to family rep cases because they operate very differently. So this proposal would clean up the law and make it more clear for the counties as far as what's required for these fee schedules, and also provide more transparency to attorneys who are taking these cases and hopefully start addressing the severe capacity crisis that we have in a lot of places in our state. If lawyers have a better idea of what they're going to get paid, maybe they're going to be more willing to take the cases. So what this law would do, it would create a new section of the Family Code, which essentially takes Article 26.05 of the Code of Criminal Procedure and then narrowly tailors it to family protection work. It doesn't create any new fees. We're not like all of a sudden saying the counties have to pay for things that are new. It's just making it more clear and tailoring it to family protection work. We did have a sub work group on this. For the most part, the large work group was in favor of this. We had one objection out of everyone who was on the work group. It was Rick Thompson, who's present here today. I will note John Dayhill, who's with the Texas Conference of Urban Counties, said he had no objection to this. I'm sure Rick can talk about his objection more if he'd like to. I think it was mostly based on the general, thought that the state currently does not give any funds to family protection representation. So it's sort of like a philosophical opposition. At the PNS committee. It's okay. I totally get it. So at the PNS committee, I believe Mr. Brennan was for, Judge Keller was not quite sure about your feeling on this one. I would like to note that there was some concern that the proposal would expand required payment for attorneys to provide services on appeal on Supreme Court appeals. And in family representation cases, indigent parents are entitled to appointed counsel all the way through an appeal to the Supreme Court. Texas Family Code Section 107.016 just say that they're entitled to their court-appointed attorney through once all appeals are exhausted or waived, basically. So, and with that, I think that's the proposal on that one.
Did you want to make a comment?
I think that's.
Okay, all right. All right, we don't have a committee motion. Is there a motion?
I'll make the motion.
Is there a second? Okay. Any further discussion?
I do have a question.
Yeah.
So who sets the fee schedule?
It would be the judges. It's basically the same rule that follows the criminal fee schedule, but it's just saying the judges who hear CPS cases would be setting it. So it's the same rule, just tailored to family rep cases.
And that creates a problem for counties because those judges they can do what they want to do and we pay the bill. And it's becoming a real issue in smaller counties.
Well, there is, the thing is, we're not creating a new law. I mean, there is this law that's in place that follows you to the Code of Criminal Procedure, which says that the judges who hear the criminal cases are to set the fee schedule, which is confusing because they don't hear family representation cases always. So it's not really creating new things. It's cleaning it up, if you will.
I don't think it cleans it up. Doesn't appear to me it does, but
I have a comment.
Yes, Judge.
My concern is that this does expand the requirement for counties, or might expand the requirement for counties to pay for proceedings that are not required already by statute or by law. For instance, there's no right to come to our court on a petition for discretionary review. Well, there's a right to come to our court. There's not a right to appointed accounts for that. And I don't know, and I've asked people since the PNF meeting, and I have not gotten an answer about whether the statute already requires the county to pay for attorneys to go to the Supreme Court, because it may not be an appeal. It's not an appeal to our courts, it's a petition for discretionary review. It may be the same thing to the Supreme Court. So until I know that, I would not want to vote in favor. I'm not voting no, but until I have the answer to that from someone who practices and actually knows whether a petition to the Supreme Court is considered an appeal and whether it's already required to be paid for, I wouldn't want to adopt this because I'm afraid that it will impose other obligations for payments to attorneys on counties that don't currently exist.
May I make a suggestion? Please. Judge, if that's your concern. Some of these things were suggestions from the sub-work group to just like further define, because a lot of the things in the Code of Criminal Procedure are just sort of broad, right? Like preparation of an appellate brief or things like that, right? So some of these were suggestions to attempt to make it more clear. But if that's your concern, rather than the whole entire thing dying, I would suggest that maybe we just take out, I believe it's subsection 4, well, the new law would be family, it's on page 184, and then on page 185, that's subsection 4. But I think your concern is on the subsection 4, where it's specifically listing and the Supreme Court of Texas.
That was the primary one. It's also subsection 3. And I also just noticed that the travel, payment for travel is not in line with what we just voted out on criminal cases. Criminal cases, it's for travel more than 50 miles. This would pay for travel from the courthouse to a lawyer's office, it looks like. And I don't think you mean to do that.
I would suggest that if there's specific details that maybe just editing them out, taking them out, or tailoring them would be perhaps a better way to handle this rather than living with the law we currently have, because the law we currently have is extremely confusing. And I actually just answered a question this week about this very question, about how do we set our fee schedule? And it came to me and OCA. So this is a problem. So that would be my suggestion. If there's things that would make the board feel better, just so at least we have a rule in place that there needs to be a clear fee schedule for family protection and use it that way.
We're coming back in December on the capital murder ones, so maybe we should come back in December with a different version of this that people can see ahead of time. Look at.
Yeah, and Crystal, I'm happy to help you on that because we've dealt a lot with the 2605 and the fee schedules and all of that. So even though it's not really my area of expertise, I think the legislative side, I think I could provide some good input. And then I'm happy to circle back with Judge Evans too and kind of walk through on what you're trying to accomplish here. So.
Okay, we currently have a motion and a second. What is the procedure at this point?
Call for vote.
Just withdraw? Well,
The motion can be withdrawn.
you know, okay.
I think I made the motion, so can I withdraw my motion?
You can amend it. You can amend your motion.
Amended, whatever.
Amended.
Take it.
Amend to withdraw my motion.
It's withdrawn for now.
But I would like to see this back in December with some revisions and one time more.
I move we postpone action till the December board meeting.
Okay. That passes.
Thank you.
So you want to
And
move on to the next one?
I'll do the next two, yes, and these might be a little more difficult to get through. I do want to thank everyone for considering these. I realize these are very novel issues for this group, and so the mere fact of considering it, I appreciate, and at least, you know, thinking about it a little bit. So the next proposal can be found on page 189. This was a proposal from Barbara Elias Percival, who is the Executive Director of Texas Lawyers for Children. This proposal is an attempt to try and fix a sadly fairly common problem of attorneys for children not visiting with their child clients. We do have a fairly long list of duties that attorney ad litem for children are required to do in Texas Family Code 107.004. One of them is to visit with your client. And so what this rule would do is it amends, and they're all listed here on page 189. It amends various sections of the Family Code. These are all in the 200s sections of the Family Code. Those are provisions that relate to statutorily required hearings throughout the life of a CPS case. And it adds a requirement that at each of those hearings, there are already admonishments judges are required to do at those hearings, and, you know, things they're supposed to ask about. This would add a requirement that judges ask the attorney ad litem for the child if they have visited with their client. Currently, the attorney ad litem is required to tell the court that they visited with their client, but often they will gloss over it or not say anything. This will require the court to ask the attorney, and the hope is that lawyers aren't going to want to just straight up lie to the court if they're being asked this question directly. And then if the court finds that the attorney ad litem for the child did not have good cause to not visit with their child, again, there's a provision for good cause. So if somebody gets sick or can't make it, it's okay, you know, life happens. But if there's no visit and no good cause, then there are some remedial measures that the court would require the attorney to take, which would be go visit your client. And then if the attorney still doesn't do that, then eventually the attorney is going to be removed from the case. There was a sub-work group meeting on this. The concerns that were raised in the sub-work group were from attorneys who work in areas with smaller lists of attorneys where we have serious capacity crisis. They're concerned that if this happens, then they just won't have lawyers to take the cases. So that was the main concern that was risen in this one. This one also does not have a committee motion. I believe Mr. Bunn was for, and Judge Keller was also not sure. I know you wanted to talk with some judges about how they felt about it. That's that proposal.
Okay, is there a motion? Or is this another one we want to?
I'll make a motion so we can discuss it.
Okay, second? Okay, is any discussion?
I'm just not sure we need this, and I really don't know enough about it. This is a whole new area for me, but it seems like this is something the judge can do anyway. And I'm in general opposed to imposing duties on judges that they have the ability to do on their own and may be doing well and considering factors that we don't necessarily know. So I mean, I'm not a big no. I am a no, but it's not, it's more because I don't know how this works than anything else.
I think the point that you made, Crystal, with if there's only a limited number of attorneys, and we had that discussion at the last meeting, there's not attorneys there. And if you have to remove that attorney instead of just admonishing them, then who do you put back in their place? And I think that's a huge problem, especially in some of these smaller rural counties. And if we're gonna require the judge to remove that attorney, what are you replacing? Or the judge right now can, just like Judge Keller said, you can ask them that and admonish them for not doing their job. And if you need to go to remove them, you can. You don't have to go to that point.
Other discussion? Well, is it really a mandatory removal in that instance?
In this particular, right now, there's no removal, but in this current rule, the court would be required to remove the attorney if they did not.
Once they're given another opportunity to
Right.
comply with the law.
Exactly.
I guess, I get it, and I guess I don't practice in this arena or in a county where you might think about this, but I don't understand the concern that we don't have, like, this is what's required.
Yes.
Like, to meet with your client. I do not think this is a high hurdle to jump over. And you're given, or at least the way it's drafted and expanded if you want to, 14, 21 days to comply. To say, all right, I get it, you're spread thin, and you make sure you get in front of your client within 3 weeks, whatever the case may be. I know when you do stuff in guardianship or whatever, I mean, you're producing a report to the court. Here's what I did, here's when I went, here's my findings, like, it's pretty detailed. I don't think it's that onerous to just say, hey, did you meet with your client? You're supposed to do it anyway. Maybe I'm not seeing some of the functional problems here, but I get it. It's a new space that we're moving into, and I think we should always encourage best practices and encourage that there's some, some movement in these cases. And sometimes you got to nudge. Sometimes the judges have to nudge these lawyers to move a little bit more expeditiously. I don't know where the right balance is, but I don't think it's that big of a burden task that would do that.
Any other discussion? Okay, I think we're gonna need hands. All in favor? Go ahead, 3. I can't see Judge Maneri's hand, but I don't think it's up.
It's not up.
Okay, so it does not pass. We do not have a majority or 2/3. All right, and the third one?
Yeah, I'll move quickly because I think I know how this one's gonna go. So I'm gonna just move that fast. So the short summary of this one would be to expand a child's right to an attorney through the permanent management conservatorship. Real quickly, when a parent's rights have been terminated to a child or they've been limited in a final conservatorship order, often the Department of Family and Protective Services is named the permanent managing conservator of the child, and that means that a government agency is technically considered the legal parent of the child. So they don't really have a human adult who's got legal responsibility for them. The current law only requires that a child have a guardian ad litem. That person does not have to be an attorney. They can be a volunteer. They can have someone who's only got 40 hours of training, and they do not have the ability to do anything that a lawyer does. The current law does allow the court to allow courts to keep attorneys for children if they want to, but they're not required to. A lot of counties are doing this. We've got 213 that report continuing attorney ad litems for children in PMC. So if this were to pass, it would affect, definitely not a majority of the counties, but it would affect some counties. So what this rule would do is it would basically require that every child in the conservatorship of the department have an attorney ad litem. There was a subwork group on this. The subwork group all resoundingly was in favor of it. They were all lawyers who represent kids. The opposition in the work group came from Rick Thompson and John Day Hill because of cost. And this went to the policies and standards meeting. I believe Mr. Bowden was for and Judge Keller was against. So
Is there a motion? I can make I move forward. There's a second. All right. Any further discussion?
Just very quickly.
What was the motion? I'm sorry.
Motion, well, on what Crystal just laid out. Whether
Okay.
you get lawyers-
Motion as presented.
Where you didn't get lawyers before.
Did we get a fiscal note from the counties?
It's gonna cost money.
I know it. That's why I'm asking.
Let me just say real quickly, I'm opposed to it for 3 reasons. One is it's gonna cost more money. 2, the judges can do it now, and a lot of them are. And I would trust the judges to make the right decision instead of imposing this on this expense. And the other thing is, if we're short on attorneys, this is going to tie them up on, in cases they may not be necessary on. So I'm against this.
Other comments? Okay. So, we have a motion in a second. We'll need hands, all in favor. And I'm guessing Judge Maderi didn't put her hand up.
I have my hand, I'm sitting on my hands.
There you go. All right, so it fails.
I'm abstaining. I'm not voting for or against.
Okay. All right, that fails. So that's all of our pending legislative work. The only other item is policy monitoring.
I'm gonna, excuse me, I hate to do this, but I have another meeting at noon. I have to run up to my office and get on that one. And it's an emergency meeting, Arvin. Thanks, everybody. We have
Okay.
time.
We still have 6, so there is still quorum to hear the final reports.
Okay.
Thanks.
Yes, on page 195, we have a summary of recent policy monitoring activity. Since our June board meeting, we've issued 3 reports to Ector, Hayes, and Gaines County. I want to congratulate Gaines County. We've completed all of their review, and they've closed out all of their findings on this 3rd follow-up review, so I just congratulate them. And on pages 198 and 199, we have our regular submissions from Maverick and Zavala counties. We've gotten some submissions from the district courts, but we've had some trouble from the county courts, but we'll keep moving. Thank you.
That's it?
Yes, sir.
Everything, all right, is complaints part of policies and standards, or is that separate now? Let's, we'll just go to it.
Yes. You can be acting chair.
Okay. No, I don't want to be. We still have Judge Maderi on the phone. He's
True, yes, he wants to.
hard to do it on the phone. Well, who has complaints?
That's me, Natalie Corvington.
Go ahead.
Good morning or afternoon now, everyone. So complaints are down, have declined by almost half. We received during this reporting period of June 22nd to August 20th, 29 total complaints. 3 of those were addressing the family protection space. So we've got about 10% of family protection complaints since we started to roll that out in the spring. Our last reporting period of March 28th to June 21st, we had 64 complaints. It was remarkably high, and so we're seeing a decline from those levels. We've revised the complaint process to streamline it a little bit better, make it easier to screen out those complaints that are not in scope, such as divorce or just general complaints about strategy by defense counsel that are not within our scope. So we're actively consulting with PPRI to streamline that process, and that is my.
Guess we can, on family protection or representation.
Yes, the last bit. Thank you for hanging in there. Okay, so we have completed our data report for fiscal year 2023. Y'all have a copy if you're in the room. Those of you have a PDF. For those of you that are new to the board, or just as a refresher, over the past 2 years, we've been collecting, well, in 2021 and 2022, we were collecting data in family protection representation, but it was on behalf of the Texas Judicial Council. And so those reports for those years went through the TJC process. This is the first year that we have official responsibility on statute for this work, so this is now coming through us. I don't believe we need a board vote on it. We just want to let y'all know that the report is ready and it's going to be out there. We think it's a nice complement to the legislative appropriations request that we currently have because it gives a pretty good snapshot of the need and where there's some work to do in the space. To give you some, you know, real quick highlights of the report, it's all here if you want to read. I find it riveting, but you know. Highlights are, you know, we've got total spending here. It's at 62.7 million. Statewide per capita is 207. We had 236 counties reporting expenditures. There's a handful that probably should have reported expenditures, but the vast majority of them that didn't are very small and don't have any CPS action happening there. Per capita spending is all over the place. As you can see, it ranges from 13 cents to $13.99, which is very interesting. That's a huge range. We also collected plan information this year. So expenditure reports come in every year, plans come in every other year, and that's information from judges about local practice and process. We did revamp the website. We were the guinea pigs for this whole new website thing. So we started the first iteration of it this year. It went okay, you know, for being the first time. I will say, I think people that work in child protection are really good at rolling with punches. So I was proud of what they were able to do. We did have 7 counties not submit their information, but mostly everyone gave some answers to what we were asking for. What we've learned, and probably no surprise to everyone here, capacity is a significant issue. We have over half of our counties reporting having 9 or fewer lawyers on their family protection list, which is not good considering these cases almost always require at least 3 attorneys or more. Sometimes you can have cases that need like 6 lawyers if they get really dramatic with different people involved. We also had over half of Texas counties, excuse me, reporting a decrease in numbers of attorneys on their list. So we asked for numbers of lawyers in 2021, then we compared to 2023, and over half of our state reported less lawyers on the list. You know, just some of the things we're hearing from courts out there is DFPS numbers are down. I mean, that's intentional. I think the legislature has been passing laws to kind of keep kids out of the system. But so that's part of it. But then we're also hearing that a lot of the cases that are there are extremely intense now. They're very hard. They're very intensive. And people just don't want to stay on the list anymore and they're leaving. So it's there's a lot of work to do there because we're reaching crisis points in some of our parts of our state. In connection with our fee schedule discussion, we had 211 counties provided a fee schedule that clearly indicated a fee structure for family protection representation. The rest of them either didn't give us one or it was criminal and didn't make any sense. We did look at pay rates, and those are interesting as well. 122 counties use just a standard hourly pay rate. So they'll say we pay, you know, lawyers by hour. Most of them, it's a single hourly pay rate. Some have a range, like that's sort of interesting. But when you look at the hourly rates, it ranges from $35 to $300 an hour. So it's quite a range. New this year, we also did attorney practice time reporting. That was a very new thing. We've never done that before either. We had over 1,000 attorneys submit their attorney practice time report. Also not bad considering we've never done this before. I don't think that's all the lawyers that take family rep cases. I do think there are plenty more. They just didn't fill out their form. That information was also incredibly interesting. Thanks to Dr. Gamble. She looked at the attorneys who submitted their reports and then compared with their bar licensure date. And what we saw is we don't have very many new lawyers that submitted their report. Maybe it's because new lawyers didn't submit the report, or maybe it's because we don't have new lawyers. We only had, of the 1,088 lawyers that submitted a report, only 35 of them were licensed between 2020 and 2023. So that's not good. And then 461 were licensed in the 1990s or earlier. So lots of work to do there. And then just to give you some general perspective on like, what are we talking about in the system? In fiscal year 2023, there were over 31,000 children in the conservatorship of DFPS. That's not all the kids that DFPS works with. Those are just the kids that are in like the legal custody of DFPS. And nearly 10,000 children were legally removed from their parents in fiscal year 2023. Other quick updates. I know everyone's like, tired at this point. We are still working on Title IV-E. That's another really exciting thing. We've been working with DFPS. We don't have an MOU for you here today. I don't know if we'd even have time to get through it if we did. But we are working on them with language, and we anticipate having an MOU in December where we can start providing some administrative support and start getting more of those reimbursements back to the counties. And then another really exciting thing, we have launched our mentorship program. We're doing it very lo-fi on a no budget kind of thing, but Natalie Corvington is doing an amazing job. She's heading that up. We put applications out. We really try to spread it far and wide. Interestingly, we only got 6 applications for mentees and 15 for mentors. We hear that usually you have trouble getting mentors, but we had trouble getting mentees. Maybe it's again because we don't have new lawyers that do this. But Natalie has paired people up, and we will do orientation in September, and then we'll provide a quarterly training in October, and that program will go through the year. So we're really excited about that. And that is it.
So I think there'll be a doodle for next meeting.
No, we have set
Got a
the
meeting?
next meeting.
All right, well, tell me
It's
what it is. Probably on my calendar.
Yes, December 6th.
Okay, then I got.
It's a Friday at 10 a.m. And we're also thinking at that next board meeting, it'd probably be afterwards, but we would like to set the year's calendar as well. We've already gotten inquiries from OCA about like when we're going to be meeting next year. So this was the first year that we've ever kind of set the whole year's worth of calendars at once. I think it helps everybody in terms of, you know, locking in those dates and trying to work around them. So we will be reaching out to y'all to try to do that again. Any new business? Public comment?
Sure.
All right, I think we're adjourned. Thank y'all.
Thank y'all. See you in December. Bye, Scott.
Bye,